Welcome. My name is Jeff Gottlieb. I'm a special education attorney located in Southern California. In today's IEP Special Education YouTube video, we are going to briefly discuss the subject of what I refer to as the power to say no, or in legal terms, the concept of stay put. To create context here, there are three sources of power that parents have to achieve the appropriate placement and set of services on behalf of their special education child. The first one is what I refer to as the art of persuasion, which is probably the most important tool that a parent has, and that is where at an IEP, either the parent or an advocate or an attorney on behalf of the special education child uses facts and information and puts that information together in such a way to persuade the school district what is appropriate in terms of placement and services on behalf of the special needs child. And again, I don't want to discount the art of persuasion because most often it is effective and it works for me nearly all the time. Not all the time, but nearly all of the time. Now, separate from that, there's two other tools that parents have as sources of power to achieve the appropriate placement and services on behalf of their special needs child, special education child. The first one of those two is the power to sue, the power to litigate. Once parents start doing that, it disrupts the entire process for the school district. They now have to hire an attorney, they have to spend money quite often. The parent may or may not hire an attorney, may hire an advocate, whatever it is, but it disrupts the entire process, not only for the parent, but also for the school district. And school districts, like any other bureaucracy, do not like disruptions. So if a parent is going to threaten to sue the school district in an administrative hearing, administrative court, the school district tends to wake up and pay more attention. So that's the second source of power. But there's a third source of power that's more passive than suing the school district, but can be equally as powerful sometimes. And that is the concept of stay put, what I refer to as the power to say no. And the best way I can explain it is through examples. And that is, here's one situation. Let's say that the school district and the prior last agreed upon IEP stated that the child is to get a one-to-one aid. Now in the new proposed offer, in the new IEP, the school district is proposing taking away the aid. The parent, let's say hypothetically, wants to keep the one-to-one full-time aid there and does not want to relieve their child of having that particular aid or an aid. Well, if the parent says no, which means they do not consent to that change, generally, not always, because there are numerous exceptions here, but generally the school district is precluded, is stopped from taking away the aid. And that's referred to in legal terms as stay put. So in that situation, what the parent would do is perhaps consent to everything, but specifically not consent to taking away the aid. By doing that, the school district is required to go back to the last consented IEP, which is typically the previous IEP. Now, a parent can choose to not agree to anything in an IEP. I'm not talking about initial IEPs because that gets a little bit more complicated. I assume in this scenario here that the student has been receiving services for X number of years, let's say 3 or 5 years. Let's say a parent decides not to sign a consent to the IEP. Now, I do recommend, of course, that you do sign that you're present, that you participate in the IEP, and if your rights were read, that your rights were provided to you. But there's usually a separate section in the IEP document itself as to consent. Quite often, there are parents who go years without ever signing a consent. And what's in place is the last agreed upon IEP, which may have been an IEP from 3 or 5 years earlier. Now, technically, stay put was written that during the pendency of a due process hearing, the school district cannot make a change to the student's IEP, except they have to keep into place the last agreed upon IEP. Now, what happens though if the parent simply does not sign the IEP, but there's no due process hearing? Generally, that's interpreted to have the same impact in terms of that the school district generally cannot unilaterally change a child's placement or scope of services unless several things are done. Either the parent consents, or the school district negotiates something different, or 3, the school district sues the parent and takes the parent to a due process hearing. Absent the last one, taking the parent to a due process hearing, generally the school district is bound to keep and to force the last agreed upon IEP. This is what's referred to as the concept of stay put. It's what I refer to as the concept of simply saying no. Hopefully this has been helpful to you. It's a little bit complex. If you'd like more information, I'm going to be shortly adding another newsletter to my website describing this in more detail. If you want to refer to my website for that information, my website is www.specialeducationattorneyatlaw.com. Again, that is www.specialeducationattorneyatlaw.com. If you have any questions, feel free to give a call to my office. My number is 562-699-2412. Have a good day, and thank you very much.